at the time of hearing and deciding the application under Section 227 of CRPC. On consideration of authorities about the scope of Section 227 and 228 of the Code, the following principles emerge. 1. The judge, while considering the question of framing of charges under Section 227 CRPC, has the undoubted power to shift the way and way the FSI case against the accused has been made known. Where the evidence for limited purpose of finding out whether or not a prima facie case against the accused has been made out. The test to determine the prima facie case would depend upon facts of each case. Second, where the material placed before the court disclosed grave suspicion against the accused, which has not been properly explained, the court will be fully justified in framing charges and proceeding with the trial. 3. The court cannot act merely as a post office or mouthpiece of prosecution, but has to consider the broad probabilities of case, the total effect of the evidence and the documents produced before the court, any basic information, etc. However, at this stage, there cannot be a roving inquiry into pros and cons of the matter and weigh the evidence as if he was conducting a trial. If, on the basis of material on record, the court could form an opinion that the accused might have committed offence, it can frame the charges, though for conviction the conclusion is required to be proved beyond reasonable doubt that the accused has committed the offence. At the time of framing of charge, the probative value of the material on record cannot be gone into, but before framing of charge, the court must apply its judicial mind on the material placed on record and must be satisfied that the commission of offence by the accused was possible. Then, Lord 6, at the stage of Section 227 and 28, the court is required to evaluate the materials and document on record with the view to find out if the facts emerging therefrom, taken at their face value, disclose the existence of all ingredients constituting the alleged offence. For this limited purpose, sift of the evidence as it cannot be expected even at the initial stage to accept all that the prosecution states as a gospel truth, even if it is opposed to common sense and the broad probability of the case. If two views are possible and one of them give rise to suspicion only, as distinguished from the grave suspicion, the trial judge will be empowered to discharge the accused. At this stage, he is not to see whether the trial will end into conviction or acquittal, my lord. Now, these are the broader principles which have been drawn by Honorable Supreme Court for a judge who is trying, my lord, at the trial court. Now, my lord, there are other judgments also which support the same analogy, my lord. This is case of R.S. Mishra versus State of Orissa and others, my lord. The relevant paragraph is 21, 22 and 25, my lord. My lord, page number 700. Paragraph 21 is there, my lord.
लाओ बहुत खाली तुमने ये कर दी लाओ
My lord. As seen from section 227 above, while discharging an accused, the judge concerned has to consider the record of the case and the documents placed therewith, and if he is so convinced that after hearing both the parties that there is no sufficient ground to proceed against the accused, he shall discharge the accused, but he has to record his reasons for doing the same. Section 228, which deals with framing of charges, begins with the word "if after such consideration." Thus, these words in section 228 refer to the consideration under section 227. This may be noted, my lord. 27, which has to be after taking into account the record of the case and the documents submitted therewith. These words provide an interconnection between section 227 and 228 that bring so while section 227 provides for recording of the reasons for discharging an accused, although it is not so specifically stated in 228, it can certainly be said that when the charge under a particular section is dropped or diluted, although the accused is not discharged, some minimum reason in the nutshell are expected to be recorded disclosing the consideration of material on record. Thus, this is because the charge is framed after such consideration. And therefore, the consideration must be reflected in the order, my lord. The same has been repeated in para 22, my lord. I won't take my lord's time on those, my lord. And para number 22, my lord. 21 and 22, my lord. Now, in backdrop of these judgments and the ratio therein, my lord. Now, the prosecution's case, as per Challan, I have already read to my lords, my lord. Mr. Tankar read it, my lord, for my lords. This is page number 28 of the A book, first book, book 1.
अब मारना मैं पोछा पूरे घर में और रसोई के लिए करनी है
जी लास्ट लाइन में ये लिखे हुए हैं सबके नाम so and so nine names are there ending with विवेक लाल पिता चंद्री ललित लाल बेथलेहम परिसर जबलपुर के रवायती के विरुद्ध जिसमें अभियुक्त अजय लाल आधारशिला पंजीकृत संस्थान के संस्था के डायरेक्टर हैं तथा शेष अभियुक्त मिड इंडिया क्रिश्चियन सर्विसेज पंजीकृत सरकारी संस्था के पदाधिकारी हैं. So final report states that I am office bearer of Adharshila and rest are office bearers of Mid India Christian Services. Now, my lords, may come to the charges, my lord. I'll take my lords to the application that I had filed, my lord, for discharge. This is at page number 25, annexure A1. Lord, here, paragraph number 4, I won't read, I won't take much time, my lord. These are the same things, the facts which have been argued before, my lord. My lord, we took that we have got nothing to do with that institution, that is Mid India Christian Services. It is only Adharshila. Paragraph number 7 also we took that, my lord. And other paragraphs, 8, 9, 10, we took everything, my lord. Now, my lord, I'll come to the order impugned, my lord, where the charges are framed, my lord. First, my application, now the application got dismissed, my lord. This page number, my lord, internal page number 44 of my application, my lord, revision application. This is order dated 22/9/44. My lord, this is order sheet of order dated 22/9/2023.
Annexure A2.
My lord,
A2 है क्या?
A2, my lord.
कंप्यूटर पे आ जाइए, कंप्यूटर से मदद करिए.
ये A2 ही है, but देखिए वो टाइप कॉपी लगेगी.
जी. क्या लिखा है इसमें?
Now, my lord, turn a page, my lord. The order sheet dated 23/9/23 may be seen, my lord.
23/9/23. DC दिनांक कितना है इतना? 22/9/23.
23/9, my lord. The next page at page number 45. Sequence.
हल्का है.
साहब.
ठीक हो गया.
23/9/23, my lord.
23/9/23.
My lord. Has, my lord, dealt my case as under, my lord. प्रकरण धारा 227 CRPC के आवेदन पर आदेश अग्रिम कार्रवाई हेतु ने आरोपी गण की ओर से प्रस्तुत आवेदन धारा
अंग्रेजी में जो लिखा उसके ऊपर पढ़ रहे हैं, नीचे पढ़ रहे हैं?
ये उसके ऊपर वाली 2 लाइनें हैं. पूरी एप्लीकेशन का जो उन्होंने सार लिखा है
आरोपीगण से प्रस्तुत
आरोपीगण की ओर से प्रस्तुत आवेदन पत्र धारा 227 सीआरपीसी पेश किया है, जिसमें सार रूप में बताया है कि
जी
these are, my lord, few paragraphs from my application itself.
जी
They do not demonstrate the entire submissions, my lord.
जी
It's part of it, my lord, which has been
क्या इन्होंने क्या
cut paste. उसके आगे, my lord, 5 जनतों पेश के बाद अतः अभियुक्त की ओर से आवेदन स्वीकार कर आरोप पत्र विचलित न करते हुए आरोप के स्तर पर ही छोड़े जाने का निवेदन किया है। प्रकरण का अवलोकन किया गया। अभियुक्त की ओर से विद्यमान अधिवक्ता द्वारा एक आपराधिक अपील WP सोएंसो प्रतिपादित दिस वाज अ केस लॉ व्हिच वाज शोन, my lord, 227 288 300 के अंतर्गत प्रस्तुत की गई। उसके अनुसार ये प्रतिपादित किया गया है कि न्यायालय में उन्मोचन के स्तर पर धारा 300 का निर्धारण कर सकती है और ऐसे उन्मोचन आवेदन निरस्त होने पर धारा 228 का आवेदन विचलित करती है। चूंकि प्रकरण में धारा 227 सीआरपीसी पर विचार किया जा रहा है, विद्वान अधिवक्ता द्वारा धारा 300 का कोई आवेदन प्रस्तुत नहीं किया गया है। जब अनुमोचन का आवेदन आता है तब न्यायालय को केवल ये देखना होता है क्या ये अवधारणा करने का आधार है कि अपराध कारित किया गया है। यह नहीं देखना है कि क्या दोष सिद्धि के आधार बनते हैं नहीं। साथ ही आरोप विचलित करते समय केवल ये देखना होता है कि जो सामग्री अभियोजन ने प्रस्तुत की है उससे अभियुक्त का अपराध करना प्रथम दृष्टया प्रतीत होता है अथवा नहीं। इस प्रकरण में साक्ष्य के प्रोबेटिव वैल्यू नहीं देखनी होती। इस संबंध में सोएंसो बचाव पक्षकार तर्क शेष तर्क का साक्ष्य का विषय है। इसका निराकरण गुण दोष के आधार पर किया जा सकता है, न कि आरोप स्तर पर विचलित किया जाता है। अतः ऐसी स्थिति में अभियुक्त को उन्मोचित किए जाने का कोई उचित कारण प्रकट नहीं होता। अतः प्रकरण के अवलोकन में अभियोजन द्वारा दस्तावेजों में then it is mentioned, my lord. So as per Supreme Court, it was to be seen and dead, and it has to be there has to be some finding which is not there, my lord. I humbly submit. Now, my lord, we come to connection A3.
जस्ट अ मिनट
None of my grounds have been either mentioned, my lord, or dealt with. Whereas in the challan itself, my lord, the registration paper of both the societies are there. Aadharshala is also there, and the papers of Mid India Christian Mission is also there, my lord.
जी
Now, my lord, may come to annexure A3, which is at page number 51, my lord.
जी यस
My lord, the first charge is आपने दिनांक 28/7/22 से दिनांक
विजय लाल के खिलाफ है।
ये अजय लाल के खिलाफ
ये अच्छा
अजय लाल पिता स्वर्गीय श्री विजय लाल आपने दिनांक 28/7/2022 से दिनांग 13/11/2022 के मध्य थाना दमोह देहात जिला दमोह क्षेत्र अंतर्गत आधारशिला संस्थान भटवारी स्थित मिड इंडिया क्रिश्चियन मिशन के बालगृह बाइबल सोसाइटी एवं बेथलेहम सोसाइटी के पदाधिकारी डायरेक्टर होते हुए नर्मदा धारा पेट्रोल पंप के सामने बेथलेहम चर्च कैंपस में अवयस्क बालिका उषा विश्वकर्मा एवं अवयस्क बालक झनक सिंह एवं अन्य अवयस्क बालक बालिकाओं का उत्प्रेरणा द्वारा उनके धर्म से विमुख कर शारीरिक शोषण किया है। Now, my lord, there are 2 or 3 things, my lord. The first is, I have got nothing to do with Mid-India Christian Services, my lord. So far as Usha is concerned, my lord, factually, my lords are already aware. This was the girl who was taken by the parents and parents got converted. Here the parents are not accused, my lord. Nobody else is accused, my lord. He got converted in Orissa, that is not under dispute. Nobody has been made. She has not alleged that I have done anything. The second, and where is the element of physical torture, my lord, of physical exploitation? She has not stated, the parents have not stated, nobody has stated. This is not even prosecution story. This was on a statement dated 12/7 by Mr. Priyank Kanungo, which was a supplementary statement.
जी.
And in this, my lord, if things are taken into consideration, my lord,
जी.
I have got nothing to do with Jhanak Singh. Now, Jhanak Singh is of MICS, Mid-India Christian Services, my lord, who was found in Bethlehem College, my lord. Bethlehem Bible College. When the prosecution itself says, I am only a director of Aadhar Shila, how come, my lord, Jhanak Singh's case, which is the case of MICS, for that could have been made out against me, my lord? And where is the element of Sharik Shoshan or Dharm se Vimukh karna? And I have no active role to play, my lord. I am not immediately responsible, my lord. There are wardens, my lords are already aware, my lord. My lords have read their statements. There are managers. So there is nothing attributable, but they say 370. Where is human trafficking in this, my lord?
जी जी. उषा के केस में भी.
Usha, if I say of Usha, there is no element of it. क्यों 11/5 के अंदर है. सेकंड में लॉर्ड, आपने दिनांक 13/11/2022 को राष्ट्रीय बाल संरक्षण आयोग के अध्यक्ष प्रियंक कानूनगो एवं राज्य बाल अधिकार के संरक्षण के आयोग के सदस्य ओंकार सिंह को लोक सेवक का दमोह जिले में स्थित आपकी भड़वारी मिड इंडिया क्रिश्चियन मिशन के बाल गृह में उनके लोक कर्तव्यों के निर्वहन और संस्था के निरीक्षण में स्वेच्छा बाधा डाल के संस्था में ताला लगाकर एवं रोलिंग शटर और रोलिंग चैनल के भीतर हॉल में बच्चों को बंद कर बाधा डाली. भारतीय दंड संहिता की धारा 186 के अंतर्गत दंडनीय होकर न्यायालय के संज्ञान में है. Now, my lord, one, that I have got nothing to do with Mid-India Christian Services, my lord.
तो आपने बता दिया.
Now, secondly is, my lord, there was no complaint by Mr. Priyank Kanungo under 186, my lord. There has to be a complaint, my lord, as per 195.
जी. वो भी आपने कल आर्ग्यू कर दिया.
उसमें एक और चीज है, बस मैं एक सेकंड के लिए आपको दिखाऊंगा 195.
जी.
195, my lord. The prosecution.
एक सेकंड.
CRPC.
हाँ.
उनको बोल रहा हूँ.
नहीं नहीं नहीं.
Let's not get 195.
डायरेक्टली हमें भी हिंट करने की कोई दिक्कत नहीं है.
नहीं.
चलिए.
हम इनको बोल रहे थे कि बोखला साहब को. The prosecution for contempt of lawful authority of public servant for offences against public justice and for offences relating to documents given in evidence. No court shall take cognizance, my lord. That I read, my lord, except on a complaint in writing of a public servant concerned or of some other public servant to whom he is administratively subordinate. I'll stop here, my lord. Complaint in writing, my lord.
Excellent. Writing of that court or by such officer of the court or that court may authorize in writing this behalf or of some other court to which that court is subordinate. जी जी.
My lord. After that also, my lord, except on a complaint in writing in the court, on that court, that is also written, but that is for the court, my lord. Here is, the first one is for officers, my lord. Now, my lords. Now, my lord, It has to be complained in writing. And what is a complaint? That has been defined in section 2, my lord.
जी जी 2D
2D, my lord. Complaint means any allegations made orally or in writing to a magistrate
जी
with a view to his taking action under this code that some person, whether known or unknown, has committed an offence but does not include a police report. Now, my lord, a complaint has been defined. So there is no complaint to the court directly, my lord, which is the basic ingredient. Rest I had argued yesterday, my lord. So 186 framing of charges directly was also not permissible.
जी
On 2 counts, one, I have got nothing to do with Bhadwari's Christian mission. And secondly, there was no written complaint to any court, my lord. It is only a written complaint was reduced to FIR, and that's how 186 has been made applicable subsequently.
जी
Now, my lord, आपने दिनांक 28 को मध्य में आधारशिला संस्थान अब यहाँ पे क्रिश्चियन मिशन बाल गृह एवं बाइबल सोसाइटी का पर तो charges could have been framed qua आधारशिला संस्थान is, my lord, I could understand, but Bible Society का डायरेक्टर पदाधिकारी Bible Society is a part of MICS, my lord. So this won't come, my lord. And 42, I have got a registration for Balgray that has been argued, my lord, and that is on record at page number 105 of the Chalan has it, my lord. The children home of Adarshila is registered, and that registration certificate is part of Chalan at page number 105, which is dated 27/2/2018.
105
105, my lord.
जी
Had the trial court looked into those documents, my lord,
जी
this charge could not have been framed.
जी
And so far as the other Bible society is concerned, my lord, I have got nothing to do with it. I am not related to it.
जी एक सेकंड
आपने 4th, my lord, आपने दिनांक 13/11/2022 को आधारशिला संस्थान भटवारी स्थित बाइबल सोसाइटी वेटरन so far as, my lord, again Adarshila is concerned, it could have been right, but so far as Jhanak Singh is concerned, my lord, it says नियोजित था उसका प्रबंधन करते हुए अवयस्क बालिका उषा और अवयस्क बालक झनक सिंह एवं अन्य अवयस्क बालक बालिकाओं के वास्तविक भरा साधन व उन पर नियंत्रण रखते हुए उन्हें ईसाई धर्म में परिवर्तित करने के लिए और उनके स्वधर्म से विमुख करने के लिए असमय कसर डालकर मानसिक एवं शारीरिक कष्ट संभव करते हुए रीति का प्रयोग करते हुए क्रूरता की और सेक्शन 75. Now, my lord, there is nothing in the entire Chalan which either shows that I had allured anybody for conversion or how could they have added, my lord, अन्य बालक बालिकाएं. There is no third issue, my lord. The Chalan does not say so. The final report does not mention. There is no statement of any children or anyone else, my lord, stating that, my lord. And there is no whisper about physical torture in the entire Chalan. So the documents itself were not seen. 75 is not made out, my lord. आपने दिनांक 28/7/2022 को 13/11/2022 के मध्य आधारशिला भटवारी में स्थित मिड इंडिया क्रिश्चियन मिशन के बालगृह बाइबल सोसाइटी बेथलेहम सोसाइटी के पदाधिकारी डायरेक्टर के रूप में उक्त संस्थाओं में हिंदू मुस्लिम बच्चों और दिव्यांग बच्चों को उनके पैतृक धर्म से ईसाई धर्म में संपरिवर्तित करने हेतु प्रलोभन, धमकी, बल प्रयोग, अपवेशन, असमय कसर, उत्पीड़न, विवाह, कपटपूर्ण साधन के द्वारा. Where are these ingredients, my lord? कपटपूर्ण विवाह. It has not been looked into. What my application was, my lord, it was a detailed application, argued in detail, my lord. And hence these charges have been framed, my lord. So I am against these charges, my lord, on 2 counts. One is what I stated in this, and other was it was important to file a revision, my lord, because had I not challenged this order, I could not have challenged the framing of charges also. This is Mr. Ajay Lal, my lord. So far as
जी
Mr. R.D. Lal is concerned, my lord, he has got nothing to do with Adarshila now. It's a other side of coin that he is not a member there in Adarshila. Charges have been framed for Adarshila against him also. So practically nothing on the record was seen. And cyclo-style charges are there, my lord. All charges are cyclo-style. They are one and the same, my lord. I won't take much time of my lord, but I'll show. My lords, we come to page number 43, A3 in this petition, that is criminal revision number 4664. 4664. Revision number 4664.
जी पेज नंबर
Page number is 43, annexure is A3, my lords.
ये तो 50 पेज से
A3. This is the last, my lord. This is the last page. Yes, please. देसी का बड़ा नहीं आगे 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 लेफ्ट साइड पीछे जाना आगे नीचे
जी जी
ये
पेज नंबर
A3, my lord.
हाँ A3 yes
A3, 43.
हाँ
Only the name has been changed, my lord. In all other cases also, the trial court has changed the name. And cyclo-style charge has been framed against everybody. There is no application of mind. There is no application of mind. No, nothing which was present in 227 application has been taken, my lord. And there is yet another supplant submission, my lord. We were talking about, my lord, the registration of Balgare Badwari, my lord. Subsequently, it got registered, my lord, under the Disabilities Act, my lord, and that document I have filed, my lord, here also. It has come with an IA. So, there
not available on record
I requested them to place it on record as well, my lord.
बोलिए इसको जो है वो करें स्कैन करके अपलोड करें
बोला था this is the registration is dated 4/4/23, which is later date, my lord. But section 89 takes care. 89 of the Disabilities Act takes care of the same, my lord. It's a
Dowry
89 of Disabilities Act, my lord. That takes care of non-registration and effect thereof. Basically, section 50 provides for registration and 89 punishment for contravention of provisions of Act or rules or regulations thereunder. That is section 89.
59 of the disability
That disability, the Right of Persons with Disabilities Act 2016, my lord. So, my lord, for others also, that charge under 42 won't lie so far as this Badwari Balgare is concerned, my lord, because
whether the certificate was available along with the charge sheet before the trial court. If it was not, then we are not supposed to look at it now. See, you are.
I agree to that, my lord. I agree to that. But that was there. Actually, I told that permission may be given. I'll file in that 482 application.
ठीक है, but
That will be
is
given.
that if that certificate was registration was
And it is admittedly post all this happened, my lord. In April it came, but 89 covers me. Even if there is a contravention, so 89 is the penal clause, my lord. So on these grounds, my lord, I am for the charge. ना.
जी बताइए.
The last is, we say, my lord, again the vicarious liability. There is no active role attributed to any of the persons, my lord, in the charge. No active role given, my lord, either in the charge sheet or while considering the application under 220.
Yes.
That's all, my lord.
जी साहब, पहले आप बताएंगे कि पहले पारिक साहब को सुनना है? पहले आपको सुनना है, पहले पारिक साहब को सुनना है?
जी,
पहले आपको सुनना है, पारिक साहब को सुनना है?
अब आप जैसा.
नहीं नहीं, आप बताइए, फिर पारिक साहब को भी सुनेंगे.
या उनको सुन ले साहब, फिर मैं बोलता हूँ.
ठीक है.
जी, जैसा.
बताइए पारिक साहब.
Malad, I'll make an endeavor to Malad stand true to my name, true meaning of my name today. Malad, Malad, I although planned my arguments in a different way, Malad, just to address this point, Malad, which the other side had just made in the end. Vicarious liability is alien.
No, first of all, you answer this thing that on page 28, a final report which says that Ajay Lal is director of Aadhar Shila institutions and other accused are connected with Mid-India Christian Services Society. So when in the final report itself it has come on record that Ajay Lal has nothing to do with Mid-India Christian Society, then how can he be roped in for the acts of MICS?
Malad, I would like to draw a distinction here.
You are required to answer that. Second is that what is the status of Mr. Priyank Kanungo as a chairman of that institution? So to invoke provisions of section 186 which are to be read with section 195 CRPC. Can he directly approach the police authorities, or is he required to follow the procedure as provided in section 195 CRPC? I am talking only about charge under 186. Third issue is that when they say that their registration was given on 4/4/23 and admittedly that registration was not available at the time of inspection, then that disability or that lacuna is covered under section 89 of the. बुलाइए, मैं इसको दिखा देता हूँ. मैं इतना इशू जो बार-बार वो करना पड़ेगा. आप इन इश्यूज को सोच के जवाब दीजिए.
Please, Malad.
They have tried to follow section 370. No, first part is that they are talking only about Ajay Lal. When the charge sheet itself says that Ajay Lal has nothing to do with Mid-India Christian Society, and the main thrust of allegation is against Mid-India Christian Society, and he has been shown as director IA.
Malad, first of all, Malad, this.
Issues बना देता हूँ, issues पे आप बहस करिएगा.
Please,
The first argument, first limb of argument addressed by Shri Shashank Shekhar, learned senior advocate, while arguing on criminal revision, seeking quashing of framing of charges, is to the effect that final report which was filed by the police authorities on 17/7/2023 makes a clear mention of the fact that accused Ajay Lal is a director of Aadhar Shila Institute, and other accused persons are members of Mid-India Christian Services. Full stop. Therefore, it is submitted that for the acts of omission or commission of Mid-India Christian Society, Christian Services, Ajay Lal cannot be roped in. Full stop. It is submitted that there is no concept of vicarious liability. Next, it is submitted that for the acts of MICS, Ajay Lal cannot be held responsible. Next, it is further submitted that no charge under section 370 IPC is made out against Ajay Lal on account of there being no allegation of trafficking against Ajay Lal in the charge sheet in his capacity as director of Aadhar Shila. Next paragraph. It is further submitted that there are two different children to whom acts of omission oblique commission have been attributed, namely Usha Vishwakarma and Janak Singh. It is pointed out that Janak Singh is admittedly a member of Bethlehem College under MICS. Full stop. Therefore, Janak Singh has no connection with Aadhar Shila. Next. As far as Usha is concerned, it is submitted that neither Usha nor her parents have stated anything about conversion. Full stop.
Or torturing.
Or conversion or torturing. Full stop. It is submitted that Usha's parents got converted in Odisha, which has nothing to do with the present Aadhar Shala institution, and therefore, for the acts of the parents of the Usha who have not been made an accused, comma, if they got converted and consequentially the adopted child follows the religion of her adopted parent, then charge under section 370 IPC will not be made out. Next. The second limb of argument is that no complaint was made by Mr. Priyank Kanungo, as is the requirement of section 2D of CRPC, read with section 195 CRPC. Full stop. Thus, magistrate, without there being any complaint made by the complainant in terms of section 2 within bracket D of CRPC, would not have taken cognizance D or the provisions contained in section 195 CRPC. Full stop. Thirdly, it is submitted that registration of Aadhar Shila Institute is available on record, which was given by the state government on 27/2/2018 under the provisions of section 41 of Juvenile Justice Care and Protection of Children Act 2015. Full stop. Thus, on the date of inspection in November 2022, this registration was valid. Full stop. Thus, it is pointed out that there cannot be any charge under section 42 or section 42 of the JJ Act. Next paragraph. It is further submitted that section 75 of the JJ Act deals with punishment for cruelty to child. Full stop. There is no allegation of cruelty to Usha, who is the subject matter of investigation in the present case wa Aadhar Shila. Full stop.
They mentioned दूसरे बच्चों को.
There is no mention of any other child in the report, in the statement given by Shri Priyank Kanungo, and therefore charged to the extent that it makes mention of other children to whom cruelty was meted out is not made out, and therefore charge under section 75 is also not made out. Next paragraph. The counsel for the revision petitioner further submits that no charge under section 3/5 of Madhya Pradesh Dharmik Swatantrata Adhiniyam is made out against Ajay Lal because there is no charge of forcing children or anybody else to conversion at Aadhar Shila Sansthan, Balgare, Damo. Next paragraph. It is further submitted that all the charges are psycho-styled and therefore there is no charge made against Ajay Lal. Next paragraph. Arguing for other revision petitioners, it is submitted that Bhadwani Institute at Bhadawari was registered on 4/4/2023. Full stop. since that has been registered subsequently, comma, and admittedly it was not registered on the date of the inspection, comma, provisions of section 89 of the Right of Persons with Disabilities Act 2016 will come into play, and no charge can be framed even for non-registration of institute at Badavari. Next para. These are the issues on which Shri Parik and learned Advocate General are required to address the court.
There's a bit of a confusion here, Malaj. I'm prevented from arguing the criminal revision petitions for two reasons, Malaj. I am not a party in those.
Aadhar Shila is not required, has nothing to do with MICS, and MICS has nothing to do with Aadhar Shila. Therefore, charges pertaining to the acts of MICS could not have been made against the personal meaning Aadhar Shila and vice versa. Full stop. It is submitted that omnibus and general charges have been framed by the magistrate without keeping this distinction in mind that two institutions are separate and there is no overlapping in their functioning.
One more minute. Bar of Section 4 under Act of 2021, Religious Act, that Freedom of Religious Act, that without there being complaint from the parents or siblings.
It is also submitted that there will be bar under Section 4 of the Freedom of Religion Act of Madhya Pradesh, in as much as no complaint was made by either the convertee or the parents of the person who was converted. Next para. Shri Prashant Singh answered this query yesterday and submitted that there are two parts to this section 4, section 3 of the Madhya Pradesh Freedom of Religion Act. इसको भी अलग से लिख के रखिएगा मेरी याददाश्त के लिए. Religion Act 2021, namely section 3 within bracket 1, another bracket small a, deals with two exigencies, one conversion and another attempt to convert. Full stop. Shri Prashant Singh submits that for an act of conversion, no police officer will inquire or investigate except upon a written complaint of a person converted in contravention of section 3 above, or his parents or siblings, or with the leave of the court by any other person who is related by blood, marriage or adoption or guardianship or custodianship, as may be applicable. But provisions of section 4 of the Act of 21 will not be applicable where an attempt to convert is being made out. Next paragraph. It is further pointed out that if an cognizable offence is committed, then police is bound to investigate it on receiving such information, and in the present case, since offence under section 370 is and 186 are cognizable offences, police was authorized to investigate the same on receiving a complaint from Mr. Priyank Kanungo or anybody else. Next. चलिए अब आप अपना शुरू करिए.
Please, Malaj. First of all, Malaj, to answer your lordship's queries,
उसको टाइप करके दीजिए.
I am today, Malaj, prevented from arguing the criminal revision petitions for two reasons, Malaj. I am not a party there. Neither the petitions have been served on me. Neither do I have a copy of the case diary.
You argue on those
I
MCRs.
have only, please. I am restricting my arguments to that, Malaj. And therefore, Malaj, I would like to start with Malaj, the learned senior on the other side, Malaj, Mr. Shekhar, had just while closing the arguments made a submission that vicarious liability is alien to Malaj criminal jurisprudence, Malaj. I agree to the extent that the same is a general principle. However, if your lordship now sees Malaj section 75 of the Juvenile Justice Act, may I read, Malaj?
Just a minute.
Please, Malad. Section 75. Whoever whoever having the actual charge of or control over a child assaults, abandons, abuses, exposes, or willfully neglects the child, or causes or procures. This here, Malad, my submission is that by the use of the word causes or procures, the concept, the principle of vicarious liability has specifically been infused in the Juvenile Justice Act by the legislature. So therefore, the petitioners are prevented from saying that since they did not have actual charge or control over the child, they are not liable. This is my first submission. If your lordship could open, on the screen, MCRC 41771 of 23, that is by Mr. Raj Kamal David Lal.
Just a minute. MCRC
41771, my lords.
41771. Yes.
If your lordship sees the whole petition, there is no mention at all of the fact that the website, now stating to be not their own, they have not pleaded that this website does not belong to them. Neither they have taken any defense anywhere, not in this petition, nowhere else in any other petition, that this website is not there. So therefore, my submission today is
That the website mentioned in the complaint.
in the complaint, in the FIR, is their own, and it is an afterthought that only yesterday for the first time a statement is made before your lordship that this is not their website.
Indeed. Yes.
In light of this, my lords, if your lordships could turn to page number 96 of this petition.
96. Indeed.
These are some screenshots taken from this very website.
Just a minute. "96" you are saying, and it's a A4.
96, my lords, it will have 96 written on top with a blue pen and circle.
Next, ये A4 बता A4 ये पूरा 96 पेज पे जा ये यहाँ से गया था 96 तो ये 96 तो आ नहीं था they should open 96 47 खुल है just as per the document still going it assessment 16 minutes. G 96 India Flags.
MadeIndiaMissions.org.
G.
Now, with respect to this website, my lords,
G.
I say that this information that this website is theirs was given to me by their own people at this time of inspection on the date of the FIR.
Yes.
And it is not their case ever before yesterday that this is not their website. Only yesterday the statement was made for the first time.
G.
Thereafter, if your lordships could come to page number 96, just 2 pages below,
G.
there is a photograph, and on top of that, it is written Dr. Vivek Lal and Angela Lal Family and Ministry.
Brief mission view. There's a photograph here.
Yes, above that, yes, my lord. Yes, my lords. Now, I would want to refer to the text, my lords. Unfortunately, this is not legible. But what I've done is, we had better copies. I've gotten it typed. If your lordships permit, I can share the screen.
Please share this screen. And ask your local council to supply typed copy also.
I shall, my lords, but there is some difficulty there. He's had a medical emergency in the family last week. He's had to
Ask him to supply when
I'll do that, my lords. I'll do that. I'm right now sharing the screen of the typed version of this. Your lordships are able to see the screen?
Just a minute. Yes.
I'm sorry, Blanche. So, my lords, on top of the photograph, there's written Dr. Vivek Lal and Angela Lal Family and Ministry. Your lordships will find that in the middle of the page here.
Ji.
Vivek Lal is the elder son of Dr. Stanley Lal and the grandson of Samuel, an orphan adopted by American missionaries. Like his father, Vivek came to the US for training where he met his wife Angela. Vivek and Angela returned to India to join the work in 1993. Vivek and Angela's primary outreaches. I would request your lordships to please note this. Vivek and Angela's primary outreaches are HIS children, service outreaches to over 120 disabled children, many of whom are severely neglected by families. And HIS serves a church strengthening ministry.
And what is HIS?
Malas, I do not know, Malas. This is their acronym given by them by their website.
ये HIS क्या है आपका?
कुछ नहीं.
कुछ नहीं.
I'll explain it. How it is nothing.
नहीं. सिर्फ हमें आपके अभी केस में नहीं सुन रहे. जब हम HIS
I really don't know. These people are also not here before my lords, but this is a document of Mr. Priyan.
अरे नहीं अभी एक्सप्लेनेशन नहीं पहले उनको बताने दीजिए जब आपका टर्न आएगा तो बताइए.
इसलिए बता रहा हूँ.
अभी सिर्फ मैं इस एक्रोनिम का फुल फॉर्म पूछ रहा हूँ बस. Nothing beyond it.
मैं क्यों बोल रहा हूँ मेरा? ये एक सेकंड मेरे को सुनने. There is a complaint before that by Mr. Priyan Kanungo. Mr. Priyan Kanungo ने ये सब लगाया है.
I understand. I agree. I'm not disputing this.
क्या है?
सुनिए वो नहीं अभी देखिए आप फिर डाइवर्ट कर गए. मैंने अभी आपसे इस डॉक्यूमेंट की मेरिट्स पर नहीं जा रहा. अभी सिर्फ मैं आपसे ये जो एब्रीविएशन है HIS इसका क्योंकि HIS कैपिटल में लिखा है that means it is an abbreviation. What is HIS children means? I only want to know this much. Nothing beyond it.
I'll ask my client.
You ask your client that. Yes, please continue.
May I stop sharing the screen now, please?
Ji, this is all you wanted to read?
From this document, yes.
Yes.
Now, your lordships have noted that it says that many of these are severely neglected children by their families.
Ji.
Now, the point that I'm trying to make here is that this website belongs to MICS, which is as per information given by them. In their own website, they write that the children there are disabled and neglected by families, their own families.
Ji.
And in light of that, I would like to counter the submission made yesterday, Balas, that in case of children living here, the GJ Act shall not apply. For which I would like to, I would request your lordship to please turn to section 2, subsection 14 of the Juvenile Justice Act.
Ji.
Section 14, subsection 14 reads, child in need of care and protection means. Now, as per me, these children are covered under two subclauses.
Ji.
One is 3A, which is who resides with the person. Now, who is the child? Child who resides with the person, whether guardian of the child or not, and such person has injured, exploited, abused, or neglected the child or has violated any law for the time in force meant for protection of child.
Ji.
Thereafter, if your lordship reads subclause 4,
Ji.
child who is mentally ill or mentally or physically challenged or suffering from mental or incurable disease, having no one to take, no one to support or look after the parents, or having parents or guardians unfit to take care if found so by the board of the committee.
जी
So therefore, on a purposive interpretation given to this section, this definition of a child in need of care and protection, my submission is that the children living here are covered under the JJ Act, and the institutions run by
living in Arunachala.
no, my lords, MICS, Baravari Chhatravas, my lords. Are covered under the Juvenile Justice Act. I would now request your lordships to please turn to section 41 of this act, and then I'll show a judgment to substantiate what I say.
जी
Your lordships are on 41.
yes
Now, the most important point in this section, as per how I read this, is the very first word, notwithstanding. Starts from a non-obstante clause.
जी
Notwithstanding anything contained in any other law for the time being in force, all institutions, whether run by a state government or by voluntary or non-governmental organizations, which are meant either wholly or partially for housing children.
in need of
Therefore, yes, my lords, in need of care and protection, or children in conflict with law shall be registered under this act in such manner as may be prescribed, regardless of whether they are receiving grants from central government or, as the case may be, by the state government or not. So therefore, the effect of the non-obstante clause here is, and this is my submission, that wherever children are being housed, and especially in this case where I have shown that children here being disabled, which is an admitted case,
जी
the organization or the institute has to be necessarily
जी
registered under the JJ Act as well, regardless of the fact if the same is registered or mandatorily required to be registered under any other law. In this case can be the Disability Act. On the last date, my lords, I referred to a judgment, and your lordships had asked me to give the citation. My lords, I'm so sorry. I could not, my lords, then, but I'm showing the judgment today. I have given a list of judgments today. My colleague there, physically present, had given it to the court master. I wish to rely on 2017.
जी
7 SCC, volume 2017, volume 7 SCC, page 594.
जी
Your lordships has that.
जी
If your lordships could turn to para 63.
जी
This is, my lords, the Supreme Court giving its opinion
जी
on children in need of care and protection. What is covered under section 2 of the 2 of the JJ Act, 214. I'm reading, my lords, section para 63. Child in need of care and protection. The provision of the Protection of Children from Sexual Offences Act 2012 do not provide for any definition of a child in need of care and protection. But no one can deny that a victim of sexual abuse or sexual assault or sexual harassment is a child in need of care and protection. Similarly, in a given case, a child accused of an offense or brought before the Juvenile Justice Board or any other authority might also be a child in need of care and protection. 64. Even though a child in need of care and protection is defined under Section 214 of the JJ Act, the definition does not specifically include some categories of children. Consequently, we are of the view that since the JJ Act is intended for the benefit of children and is intended to protect and foster their rights, the definition of a child in need of care and protection must be given a broad interpretation. It would be unfortunate if certain categories of children are left out of the definition, even though they need as much care and protection as categories of children specifically enlisted in the definition. Beneficial legislation of the kind that we are dealing with demand an expansive view to be taken by the courts and all concerned. 65. In Workmen versus so-and-so, this court held in para 4. The principles of statutory construction are well settled. Words occurring in the statute of liberal import, such as social welfare legislation and human rights legislation, are not to be put in Procrustean beds or shrunken Lilliputian dimensions. In construing these legislations, the imposture of literal construction must be avoided and the prodigality of its misapplication must be recognized and reduced. Thereafter, the Honorable Supreme Court refers to other judgments in the line and therefore concludes that the definition of the term children in need of care and protection has to be given a wide.
Where is the conclusion? Where is the conclusion?
Para 69. That and thereafter was the issue of child care institution starts. I had already referred to this on the last step when we were arguing the petition by Mr. Ajay Lal. So, my first point here is that it is incorrect to say that this institution, this organization, MICS, which runs 2 institutions, is not required to be registered under the JJ Act. Thereafter, if your lordships could now please turn to the writ petition.
Which writ petition?
It's the same, 41771. I'll be arguing only from this, nothing more. And page number 43 thereof. Annexure A3.
A3?
Yes, my lords.
Yes.
This document happens to be an MOU between 4 people. The petitioner here, one Vivek Lal, one Mr. Vivert Lal, and one Mr. J.K. Henry. These names are important, your lordships may please note. All these are members of MICS, the umbrella organization. It is not disputed that they are not members. By virtue of this mutual understanding, which is nothing but a notarized document, no authenticity, nothing that is coming out from this document. They say they have diversified their roles, they have given distinct responsibilities to each other, and therefore one unit head, the term used by them, is not responsible for anything done by the other unit, which is headed by somebody else, which may be headed by XYZ, we don't know. As per this at page 44,
Page 44, yes.
Raj Kamal David Lal as MICS, Media Christian Services, next to it, point 1, happens to be a parent organization located at District Damo, MP so-and-so. And at the bottom, J.K. Henry, Bethlehem Bible Institute.
Happens to be a unit of Mid-India.
Correct. So this is an admitted case. In light of this, if your lordships could now turn to the very much spoken about the joint magisterial inquiry, which starts at page 47, and I am referring to the relevant pages, which are the findings, which start at page 66, written on top and circled.
Page 66.
Please, my lords.
Yes.
Your lordships, at the bottom, somewhere in the middle of the page, would find Bindu number 1.
Bindu number 1, yes.
Yes, these are the findings. That is where point wise.
एक मिनट रुकिएगा प्लीज. अच्छा आप ठीक है वो कल मैंने एक येलो कलर का हाईलाइट कर लिया. Now I want to highlight in some other color. How to go about it? मैं अभी तो येलो ही आएगी. कलर चेंज करना चाहता हूँ. जी.
Why I invited your lordship's attention to these pages to show that this is where the findings start, my lords. If your lordships would now turn to page 68.
तो आप बताना कहाँ चाह रहे हैं? You point out specifically and specifically.
All right. I'll do that. 68.
Page 68, yes.
Yes, my lords. Point number 2 here is Bethlehem Sansthan. There's another small paragraph below that, starting with National Theological Association.
जी.
I would like to refer to this. National Theological Association Mumbai, India, registered with so and so के द्वारा Bethlehem Bible College. Your lordships, please note the word college.
जी.
Now, the Bethlehem Bible Society has now become a college. Bethlehem campus दमोह को बैचलर ऑफ थियोलॉजी की डिग्री देने हेतु वर्ष 2021 से 2025 तक के लिए अधिकृत किया गया है. Now they are providing a degree course in the subject in the genre Bachelor of Theology. Now the permission that they say, that this report says, has been granted to them by one National Theological Association Mumbai. Now the question, my lords, that I ask myself, whether an association, which is just a group of people coming together, forming an organization and an association, is competent to grant accreditation to any other.
Is it the scope of the MCRC? Because
I tell you why, my lords, I am bringing this to your lordship's notice.
Please bear with me. Your Advocate General is required to answer that what investigation was carried out on this aspect, whether they are entitled to, because that is not the gist of your complaint. So don't stretch something which is not the gist of your complaint. Gist of your complaint is that inspection was carried out, certain children were found to be sort of imprisoned, gates were not opened, they are in a very precarious condition, there is lack of registration in these institutions. That is the gist. So when you are arguing on section 4275, I did not interrupt. But if you try to extend the scope of this, then your Advocate General will be in hot waters. He will be required to answer that what investigation was carried out and whether your IO had gone to Bombay to find out what is the status of this National Theological Association and whether they are entitled to give any degrees or any recognition or affiliation or not. So if you want to extend the scope, you and your Advocate General both will be required to answer it.
Milords, I am most humbly submitting, I am not extending the scope of this, Milords. May kindly allow me to.
Don't divert. If you divert, I can extend the scope. This hearing can go on for months together, and we will not reach anywhere.
No, my lords, my only.
No.
My only. Allow me, my lords, may allow me to at least complete this sentence, my lords.
Please first point out from this that this is part of the charge sheet, and any charge has been framed on this aspect.
No, my lords, this is only to bring to your lordship's kind notice that the situation which has been created there by the petitioners and their organization is of complete lawlessness, my lords. They're doing whatever, my lords.
Mr. Priyank Kanungo did not conceive this, as you said that it is their afterthought. They had never said about their website. It is also an afterthought on your part. Mr. Priyank
No,
Kanungo,
my lords.
Mr. Priyank, show me from the complaint or statements under 161 that Mr. Priyank Kanungo said anything about this National Theological Association or its recognition or its capacity to give recognition.
My lords, it is only when, my lords, may kindly.
I'll not permit you. I'll not permit you like this. Things cannot go uncontrolled.
I understand, my lords. May now read further of this report.
Yes.
There is a table, my lords. The table had been shown to your lordships yesterday by the learned Advocate General. Just below the table, I'm not going again into the table, point number 2 and 7, where the petitioners appear. Just below the table, it is written, जांच के दौरान अवगत कराया गया है कि संस्थान के डायरेक्टर संचालन डॉक्टर अर्नेस्ट मैकफरलैंड हैं। पूर्व में डायरेक्टर संचालन डॉक्टर जेके हेनरी थे। Now the point that I'm trying to make here is, well, there are 4 or 5 people interchanging names and interchanging head units. Sometimes somebody becomes a head unit of something, some unit, thereafter somebody else becomes, and their submission before, whenever anything comes up before your lordship or before any other court or tribunal, they come and make a submission that I was not there at the time.
You are required to answer what was argued by Mr. Shashank Shekhar yesterday, that Angela Lal has been given clean chit. Another person has been given clean chit and no charge sheet has been filed against her or him, whatever is the case. I am not sure about their gender. Then, no investigation was carried out, no charge sheet has been filed against either Ernest McFarland or J.K. Henry. Advocate General yesterday said that investigation is still going on. But when charge sheet against them for the present, then can you expand the scope of 482 petition by reading all those things which are not relevant?
No, my lords, these are absolutely relevant, my lords, and this is not a document relied on by me, my lords. This is a document relied on by the petitioner themselves, claiming that this document gave them a clean chit, my lords. It is my duty to bring it to your lordship's
Then
notice.
you are required to show that what investigation was carried out on these 2 lines. You will read every line, I'll ask you the same question.
My lords,
If you are able to convince me that that has relevance to the controversy, as you were arguing earlier, I never interrupted you. But unless you are able to point out the relevance of that particular lines, I will not permit you to read that.
my lords, the relevance I most humbly submit.
Please show the relevance, please show the relevance.
I am submitting, my lords, may kindly bear with me. I am saying, my lords, the relevance here is, my lords, that these 2 units, which claim to be, which are admittedly and undisputedly units of MICS, are not governed by any provision. They are not performing or they are not statutorily recognized by in whatever they are doing, my lords.
तो किस सेक्शन में चार्ज बना बताइएगा, चलिए आपकी बात आगे बढ़ाते हैं.
My lords, I don't wish to, my lords, expand the scope. I am only.
बैथलम बाइबल कॉलेज के संबंध में क्या चार्ज बना है, चार्ज पढ़िएगा कि ये बैथलम कॉलेज जो है ये अनऑथराइज्डली चल रहा है, ये फर्जी डिग्री बांट रहा है या अनरिकॉग्नाइज्ड डिग्री बांट रहा है, वो चार्ज बताइए, फिर उसके ऊपर बहस करिए.
My lords, with respect, my lords, that is not my duty to answer, my lords.
If it is not your duty,
Not
then
being the state.
then it is also your responsibility to not to argue vaguely. You are supposed to answer precisely.
My lords, I bow down to that, my lords. If your lordships could now directly please turn to page number 90,
90,
their
yes.
own document.
Yes. 90, yes.
90.
Yes.
This is, my lords, the letter written by me.